Всем добрый день. Меня зовут Александр.
Hi everyone, I'm Alexander. I'm the CEO from Stakhanovus, and I would like to make you relaxed, a little bit more relaxed after such technical presentations. We'll consider some practical cases from judicial field, insider, and how to become a defendant in the court. We'll find different cases, court cases, and how the employer may become a defendant in the court, and a case of a defendant who proved innocent. What's employee monitoring and ELP systems? Just find out about terminology. You may be all aware of these things, but let's clarify. Employee monitoring systems are systems for automatic registration of the activities.
И сохраняет в качестве доказательной базы для того, чтобы можно было в последующем эту информацию
So that we can later process this system. DLP is the data leak prevention. This system is created to prevent leaks and understand which data was leaked and take measures against those people who were guilty leaking the data. These things allow you to run investigation and keep the evidence that you can use in the court. So what makes these systems useful in the court? First of all, they figure out the fact of the violation. They find the person to blame, the one convicted, and find the connection between the actions and the results. Most of the employers cannot prove that this particular person had committed that particular violation for which he had been fired, like, for example, for disclosure. Sometimes the person may be fired for disclosure, however, there was just a leakage. So by law, you cannot fire people for that. You just need to prove and find some evidence. To find this in the court and use it in the court, you need to legitimate DLP systems. Legitimation is the measures to document, inform the people about the use of such systems and collect their consent. If you legitimate such systems, it may be useful in certain cases. First of all, you check the requirements and comply with the legislation. You will reduce the risk for finding responsible, and you will. Otherwise, if you conceal, you'll be found responsible for recuperating the damage. You'll be affected by fines, different other sanctions, and even criminal records if it had not been legitimated and the person working in the security service had been looking for personal mails of an employee for some particular reasons. How do we legitimate employee monitoring or DLP system? First of all, we run policies of the use of the corporate resources in the company and find it simply written on what is allowed to do at work and what's not allowed to do. What is allowed to use on a computer for personal? This is you cannot use personal email, etc. There should be an order given to implement the monitoring system or DLP and notify the employees about such monitoring and get their consent. You can sign an agreement with them with the additional agreement to a contract with the employee. And basically, I should say that we have our own policies that we have prepared for our customers, partners, so that they can use them. That's the policy of using that texts that can be used to legitimize this in the system. Now I would like to move to the next thing. There are 5 mistakes that they make in the court. We've checked the judicial practice, and sometimes DLP and employee monitoring systems are used, and they have a court investigation, they have a trial, and they find defeated. What are the most common mistakes that the employer makes? Mistake number 1. So let's just stop at some practical aspects. So in order to use this as evidence in the court, we just need to stick to the following rules. It's whether the evidence is related, whether this is related to a certain violation, and the evidence you've collected is the thing that can be used against the employee. The legitimate use of the employee monitoring systems, you need to find that the evidence you have collected is legitimate. If it's been collected in a non-legitimate way, the court may just decline this evidence. The precision of the evidence, that it's not doubted, it's not random, and it does relate to the employee that is our focal point. And the evidence should be sufficient to make sure that the court finds your decision lawful. What would be the mistakes? Mistake number 1, the company has not provided the full list of the confidential documents. The project manager, deputy director, has sent a template of a contract and the information related to the medical information of an employee, and this person was immediately fired for the disclosure of medical information and other information, but they did not make sure that it did not contain the personal data, because they wiped out everything which related to the private and personal information. So they fired the person for disclosing commercial information and medical information. However, such information was not there. So the 1.5 million rubles was paid as a compensation as a result. The second case, the employer did not provide evidence of disclosing this information, and the chemical research facility, an employee has copied a lot of information on a flash drive, then it sent it to the employer. DLP system detected that, and this person, this female employee, was fired for the disclosure of the commercial secrets. The Court of Cassation later defended the employee because the fact of sending the flash drive to someone has not been proven. The disclosure case was not detected. The next one, the commercial secret. The security expert has sent information to their colleagues. It was detected and it was fired for the disclosure of commercial secrets, but it did not verify whether those people had access to that commercial secrets. They did have access, and what they sent was quite legitimate. So, of course, they were recovered in position, and they had to pay the fine for downtime. The next case, overstated aggravation. Deputy head of the equipment department sent information about the hardware, and he was deprived of a bonus payment. He sent a lawsuit, he initiated a lawsuit, and then he proved that the files that he sent did not contain any information, any special information, because that did not have any secret in there. So the employer could just reprimand the employee and did not impose a fine. Another case, the generating company, the DLP system detected that the employee was tackling some personal business in the working hours. So he was fined for that, but it was figured out that he was just doing it during his lunch break, and he was not trying to damage the employer, so the measure was taken was too strict. Another mistake that I would like to cover is a strict case here in terms of the employer violating everything that they could violate. There's a construction system, and the DLP system figured out that there was a master using his private emails, sending private emails with another company that was constructing a gas pipeline. He received a reprimand, and he actually tried to prove innocent. He was sending emails to the contractor, so it seems like that they were trying to punish that person by the use of the DLP system. So the employer could not really find evidence that this employee was actually violating something, and the employee was not even given his personal instruction. And basically, the employer wanted to fire that person and was trying to find reasons for that and couldn't really do that. But there are very other cases, failed cases, but there are also successful cases where the DLP system was used properly. We find some open sources, and these are the things that are related to the Stakhanovitz solutions. Stakhanovitz was actually tracking out the activity of the users. There was a person named Mr. Bazhin. He was sending a lawsuit about complaining that he had been fired for copying 6,000 files on a flash drive and sent his private and personal data to competitors. It had been detected, and the person was fired. He wanted to prove innocent, however, he failed to do that. The next case was more difficult. It was the criminal case against Mr. Korobeinikov, who was getting access to the commercial, banking secrets and computer information. Mr. Korobeinikov had been working in a previous place. He left that job and he found a different job elsewhere. And in the trial period, he installed some software on a computer. After a while, it was figured out that they were trying to connect the website of their former employer, and he was copying the files through their mail. However, it was said that after a while, the FSB employees were taking the data off the computer which was used by that employee. So this particular case shows that the employer was quite successful in terms of proving that they were not accomplices, and this employee had been found guilty and had been imposed a fine, a sizable fine. Yet it was a criminal case already. And one final case, which is a very interesting one, which was in the Supreme Court of the Republic of Bashkortostan. There was a lawsuit against the employer, Mr. Khaybulin, and 86 other violators. Mr. Khaybulin had been deprived of a bonus for idling during the working day. He wanted to prove innocent, and then they checked the information that they were idling. They were looking at different materials. They were watching porn films, and they were watching entertainment programs. So the employer could actually prove that the disciplinary measure taken was quite proper. They could collect evidence. If they had not collected the information, the court would have protected the weaker part. What about Stakhanovets? Stakhanovets is our company, is the product. That's the DLA monitoring, incident control system, the analysis of the working time efficiency. It's just like a Swiss Army knife solution which can be used everywhere. We started working in 2009. We've been working for 14 years. We've had 16,000 customers. We've had 1.5 million implementations. One part on the computer, another part on the server, and the end user machine. We have patents for these inventions. So we are registered in the Uniform Russian Register. We are certified. A couple of words about how it all works with us. It works based on the client-server architecture. The client uses the agent without any interface. The data is sent to the Postgres or MySQL or Microsoft database, and the report about what the employer has been doing is getting through the use of the browser. So you can open this browser and find what this person has been using this browser for. We have behavior analytics. This allows you how to compare the behavior of one employee against the other. The systems collect a lot of data, but it's very hard to single out the proper things, especially when it comes to cases when the information security is at a very low level and the information security tools are very, very poor ones, very low-level ones. So it's very easy to detect how the behavior of different people differs, find out the outsiders, find out the leaders, and tackle those that you dislike the most. So there are standard deviations from the group you detect, and you measure those people who either send some information very often or find the most number of the incidents, and it becomes much more easy for you to analyze it then. It analyzes the involvement of the people in their work. Physical safety is the anti-photo system, which prevents you from taking the pictures of critically important information or sites. For example, if this person is working for a cellular company, a mobile service, a mobile provider, and if they have an access to personal data, if he's not supposed to take a picture, they can use the function of anti-photo, and it will fold this at the moment when they will try to take the picture. And the face recognition system, which allows you to evaluate whether it's the right person sitting at the working station or there may be some alien person. If there is an alien person, this account will be blocked. The voice DLP, which analyzes the negotiations, if there are some document numbers mentioned, names, second names, the security people will be prompted that the risk words from the risk word dictionary have been used. Watermark systems, all the screenshots and fragments of screenshots will be marked with the special watermarks. If this screenshot is found on the internet somehow by these watermarks, it will be easy to understand that this screenshot was taken, when it was taken, and by whom it was taken. What are the functions? We have all of the functions that the standard monitoring and DLP systems have. We can monitor everything, what kind of messages this person was sending, which sites this person was visiting, and different other analytics. It's the automatic risk analyzer over the last 6 months, for instance, and you'll be able to see those people who seem suspicious to you. For all of the participants of this today's event, we have prepared a special offer. By using this QR code, you can get a 30% discount for annual subscription license of Stakhanovets Pro. You're welcome to take a picture here and fill out a form, and you get an additional discount. I'm done with this presentation. If you have any questions, I'm open for them.
Да, прошу.
Yes, please.
Смотрите,
Well, there is a list of critically important tools. Either it's an app or a browser tab. So when they open a CRM system, an application, a webcam on a notebook or a stationary camera initiates, and in real time it analyzes everything which is happening in front of the picture. At the Stakhanov demo stand, we showed you how this anti-photo is used. If the mobile phone is placed horizontally or vertically, at this moment the system detects that there was a possible attempt of taking a photograph of a screen. The app is blocked and the photo of that event is sent to the security person. And so the security man will get this snapshot and what was happening at the screen, whether there was a false positive, whether there was a real threat, but they will at least have this notification. There are some questions off the mic, we can't hear them. The answer is that this camera is reacting to mobile devices. That does not recognize anything. But if this person is equipped with some secret camera which is embedded in the glasses, for instance, a different level of security is required here. And the engine identifies the shape of a mobile phone. We train that on a different mobile phone, and it will definitely track any Nokia. It will definitely track any Nokia. You can come up to our demo booth, and I can guarantee you 30% that these mobile phones shapes are pretty standard, so it will detect it. What about standard cameras? We did not train this for standard cameras, but if a person comes up at work with a camera, it will cause more suspicion. It's very hard to imagine a person coming up with a camera to take a picture. It seems like it's going to be a gross incident. It depends on the policy of the company. Sometimes you can get it as a misdemeanor, but somewhere people will treat it more loyally, in a more loyal way. So you just need to provide this as a protection from taking a picture of the screen. For example, a regulator is asking a question, what measures are you taking to protect taking pictures? So you can say that there are some solutions here that we provide. I would like to thank you all.